Hello, everyone, and welcome to our Experienced Practitioner webinar. Today, we are going to be talking about trademark ex parte, expungement, and re-exam proceedings. I'm Jason Lott, the managing attorney for Trademark's customer outreach at the USPTO, and I'm so happy that you are here to cover this topic. And we are very fortunate to have two great experts with us today who are going to be telling you all about these different sorts of proceedings. I'm going to introduce them in just a couple of minutes. But I did want to thank you for being here today. As you may or may not be aware, we do try to do an experienced practitioner webinar 4 times a year. Once every quarter. It's typically on the last Tuesday of the quarter. So that's going to be March, June, September, and December. So if you're one of those people who likes to think ahead and sort of plan ahead, that is when we try to do them every single year. So at least 4 of them. And we also try to filter in an additional experienced practitioner webinar from time to time. We might have one coming up on August 26th, so keep an eye out for that one as well. But we want to make sure we're giving you the information that you need so you can do the best job you possibly can in your practice. And so we're going to be covering something today that is hopefully going to help you in your practice, whether it's improve something you're already doing with expungement and re-exam proceedings, or if you haven't used them yet, maybe it's an opportunity for you to start using them once you see their value. So that's what we're going to be talking about today. But before we do, I do have to cover a couple of quick housekeeping things. I'm sure that somebody's going to ask the question, if they haven't already, is today being recorded? The answer is yes. And also the question, are the slides available? And again, the answer is yes. The slides were available beforehand. They're also available now. So throughout the day today, Chris, our WebEx technician, will be popping a link to the slides into the chat. So you're welcome to download a copy of the slides. If you don't know where the chat bubble is, look in the bottom right hand of your screen. You'll see a little bubble that says chat, and chat is where you want to go. That is where Chris will be communicating with you today. If you're someone who wants or needs captions, that's also available there in the chat. Chris is going to pop in the link to the live captioning. If you want to have machine captioning, that's fine, totally your choice. You can use the CC button in the bottom left-hand part of your screen. But if you want human-generated captions, we would encourage you to grab the link that you find in the chat. And throughout the day, as I said, Chris is going to be putting in a link to the slides. If there's additional information through various websites, Chris is going to be popping those in there as well. And that is also where you can communicate with him if you have some sort of technical issue that you're running into with the WebEx. For example, you can't hear anything, or you're hearing music or an echo or something along those lines. You can message Chris in the chat and say, hey, I'm having this issue, and he'll do his best to help you out. Now, oftentimes what that means is leaving the WebEx and then coming right back in, and that solves everything. But I'll leave all the technical fixes to Chris. If you do have a substantive question about the topics that Christiana and Catherine are talking through today, you're more than welcome to use the Q&A to ask that question. If you're looking for the Q&A bubble, you probably don't see it. But look in the bottom right-hand corner of your screen. You're going to see 3 little dots. If you hover over those dots, you'll see panel options or something like that. Click that, and then that'll open up, and you'll see a link there to the Q&A. And you're more than welcome to use the Q&A to ask us questions. Now, to be clear, we're not going to be answering questions in the Q&A box today. Frankly, there are just going to be too many of you in order for us to do that. But what we're going to do is use that to collect your questions and your comments and your feedback. And so when we get to the end of the presentation, I'm going to try to filter in some of those questions that you've asked today, but also we're going to be covering questions that have been previously submitted via email and other means. And things that we want to make sure that we it's information that we get out to you. But I'm going to try and bring in some of the questions that you guys ask today as well. So please feel free. And even if we don't get a chance to answer your question, we are seeing it, and it's going to go into figuring out how best to communicate about these practices going forward. So it's trust me, there's value to it. Okay. And also, please don't take it personally if we don't get a chance to answer your question. We had over 1,000, almost 1,500 people who were registered for today. So that's a lot of people. So we probably wouldn't be able to get to every single question that you ask anyway. Well, one way to make sure we get to the questions is to actually get into the presentation. So let's do that. Let me introduce you to our two experts here today. First is going to be Christiana Schwab. She is a senior attorney advisor in the Office of the Deputy Commissioner for Trademark Examination Policy. She started at the USPTO in 2014 and is currently a member of the working group that examines expungement and reexamination petitions. She's a graduate of the University of Michigan and University of Michigan Law School. We also have Catherine Tarku, who graduated from Franklin Pierce Law Center, now known as the University of New Hampshire School of Law, with a concentration in intellectual property. She's an attorney advisor with the Office of Petitions under the Deputy Commissioner for Trademark Examination Policy, and she also is currently a member of the working group that examines expungement and reexamination petitions. She is licensed to practice in Virginia and the District of Columbia, and both of these folks are some of the top experts when it comes to these things. We always do our best to make sure that you have top of the line folks who are giving you the information, and by all means, that is the two that you're going to be hearing from today. So I am going to step out of the way so that Catherine can begin the presentation, and then I'll be back at the end of the presentation to ask them questions, both things that were previously submitted, and we'll try to bring in some stuff that you folks have asked today. So let me turn it over to our two experts, and I will see the rest of you folks in a little bit.
Great. Thank you so much, Jason, for that wonderful introduction. Christiana and I are very excited to share with you all the information about this area of law that we've been spending the majority of our time working on these days. Basically, if we don't have the answer for you, it's probably because we haven't seen it yet, because we have basically been working on these petitions since day one, so we have basically seen it all so far. This presentation is geared towards experienced practitioners, of course. So unlike in other presentations that we've given on this topic, we're not going to spend a lot of time on the background or filing basics for these proceedings, but we do have plenty of information available for you all on our USPTO website. You can search TMA or the Trademark Modernization Act to pull that up if you do need more detailed information. We really wanted to focus on providing you with the information on how these proceedings can best benefit you and your clients, and to give you tips to make your petition succeed. However, no presentation would be complete without some sort of introduction on the topic, so we're going to jump right into that. The goals of the presentation are first and foremost to provide you with insights on the history and purpose of these proceedings. We're going to define use in commerce, since that is basically what these proceedings consist of, making that claim that a registrant is potentially not using their mark in commerce. We're going to focus primarily our time on establishing that prima facie case of non-use that you must make in your petition in order to get the office to institute. And then we're very proud to share some of our 3-year anniversary highlights, where we've come, and some of the success stories that we've had with our director-initiated proceedings. And then, of course, we'll give you best practices, tips, and other insights for your petitions. Okay, so the Trademark Modernization Act, otherwise known as the TMA, only became effective in December of 2021, even though it was enacted in 2020. And we really only started working on these in the office in the beginning of 2022. So like I said previously, it's only been about 3 years, we're going on our 4th year now, that we've been working on them. So essentially, they are still a relatively new tool that we have been using to combat potentially unused marks on our register. It created the 2 new petitions are the expungement and reexam petitions, and I'll explain the difference. But both were designed to be a faster, more efficient, and less expensive alternative than going to the Trademark Trial and Appeal Board. And we view them as a supplemental tool for clearing out deadwood that perhaps you can use before a registration files their maintenance requirements. For example, when someone is required to file their Section 8 between that 5th and 6th year, they are required to go ahead and delete out any goods or services that are not in use in that registration. However, like I said, you have to wait for the 5th and 6th year, and then there's the grace period. So if a petitioner doesn't want to wait to see if the registration could be updated during that maintenance filing, you can use one of these petitions to go ahead and attempt to get that mark either canceled in whole or canceled in part based on a claim of non-use. This slide represents a bit of the procedural process for these proceedings. For example, these proceedings can be filed by both a third-party petitioner, such as yourself, or by the USPTO itself, and that is what we call a director-initiated proceeding. So that's pretty unique that we allow two different parties to file these proceedings. I touched on this a little bit already, but the proceeding can be initiated against the entire registered mark in full, or perhaps if it's a multi-class registration and you only want to target one class, you can go ahead and just petition against one class. You do pay $400 per class to file the petition. So that could be a cheaper option for you if you wish to only petition one class in a multi-class registration. Or you could petition against certain goods or services within a class. So again, you do pay $400 per class, not per good, but sometimes what we see is when a registration has what we call disparate goods in a particular class, for example, in, let's say, International Class 9, perhaps a registered mark has tons of computer hardware and software, but then they randomly have something in there like sunglasses, and you're a clothing company and you want to petition just against those sunglasses, you can certainly do that as well. We do ask that you consider, what would be the best bang for your buck with filing these petitions. For example, if you've received a Section 2D refusal, make sure that you're including, all of the related goods and services in your petition. If you're providing shirts and the registrant has a whole, paragraph long idea of clothing goods, it's probably in your best interest to target all of Class 25 as opposed to just petitioning against their shirts, since typically the office does cite all related clothing items against each other. But do keep in mind that you have to make your prima facie case of non-use against every item or related items in your petition, which we will get into in a later part of this presentation. Another unique feature of these is that with third-party petitions, they can be filed anonymously. However, they cannot be withdrawn once they are filed. So we do get a lot of questions on this because a lot of times a petitioner will file a petition and then they'll enter into settlement negotiations with the registrant and the petitioner will want to withdraw. We cannot allow withdrawal for two reasons. The first is if that petitioner does in fact make his prima facie case, his or her prima facie case, we are required by the statute to go ahead and follow through with that institution. And second, because once we do institute, that petitioner is no longer part of the process. So the petitioner files the petition. If you make your prima facie case, the office takes it over, we institute, and then the petitioner is no longer part of the process. So therefore, you can't withdraw because you're no longer part of the process. Eventually, so once we institute, these can go to the final stage, these can go to the request for reconsideration stage, these can go to the board, but eventually it's going to come down to whether or not we terminate the proceeding and accept the registrant's arguments, basically accept their showing of use and leave the registration as it is, or perhaps we only cancel a few goods or services or a class within a registration, or if ultimately we find that the registrant has not met their burden of proving that they've used the mark in connection with the goods or services, we'll cancel the mark either in whole or in part. The director-initiated proceedings, we're going to talk about those later on in the presentation, but in order for the director to institute against a mark, we do exactly the same process that petitioners do. We do our own search, we make our own prima facie case of non-use, and we build the record for the petition showing our investigation of non-use as well. Essentially, if the office is bringing a petition against a registrant, we want to make sure that we feel very confident in moving forward with that. And as you'll see coming up, we have been very successful with our director-initiated proceedings. Okay, so expungement. Expungement is basically the avenue that you would use if you want to make the claim that a mark has never been used in commerce. This does not mean that a mark has been abandoned. Let's say that a registrant was using a mark for a period of time and then discontinued use. That would be a potential abandonment claim that may be more appropriate to explore through a TTAB proceeding. But rather, expungement is a claim that it has never been used at all in commerce that can be regulated by the United States Congress. This is available for all filing basis, so registrations that were initially filed under Section 1A, 44, and 66. And in order to file under expungement, the registration must be between 3 and 10 years old. When the TMA originally went into effect, we did offer a temporary period where you could bring an expungement claim against a mark regardless of its age, but that exemption did end in 2023. So unfortunately, if you're looking at a mark that is older than 10 years old, you would not be able to file one of these proceedings against it. On the other hand, we have reexamination. Reexamination proceedings are available only for Section 1A registrations that were initially filed under 1A. And this is most likely what we commonly use for our director-initiated proceedings. And that is because you have to file a re-exam proceeding within the first 5 years post-registration. And with our director-initiated proceedings, we definitely would like to investigate non-use before having a registrant potentially file their maintenance document down the road. What's very important to highlight with the re-examination proceedings is that we have a relevant date. And this is extremely important for petitioners to get correct. So with the relevant date under re-exam, you have to establish that the mark was not in use as of that date, which if the application was originally based on Section 1A, that relevant date is the filing date of the application, not the registration date of the application. So sometimes petitioners do get that confused. Or if it was based on 1B or amended to 1B, it would be the end of the statutory period to file that statement of use. So very important when you're doing your research on non-use to make sure that you are establishing non-use as of that correct relevant date. Okay, our next couple of slides are basically showing our statistics and filing numbers. These are the numbers that we have gathered since 2021 through May, so last month. So we don't have the statistics for June. But you can see that based on third-party petitions that we've received from the outside, we've almost received about equal numbers of expungement or re-exam, slightly more re-exam. But what is important to note is that we tend to institute almost equally in the same amount of times based on whether or not it's expungement or re-exam that's coming forward on the petition. And that most of the time, about 60% of the time, we are instituting. And that does mean that petitioners are meeting their evidentiary burden, which is fantastic. That means you guys are doing a fantastic job. But we want to help out that other 40% of filers so that these petitions are totally worth it for you and your client and that you'll continue to explore them. And then what this slide also shows is that in 75% of the case where we go ahead and institute, we are canceling at least some form of a good or a service or a class. And in 98% of these filings, we are canceling the entire registration. So the success rate for these petitions is overwhelmingly positive. As long as you meet your initial burden of making that prima facie case of non-use, the success rate of at least partially canceling or canceling in whole for these is tremendous. For director-initiated proceedings, you can see here we do have a very large discrepancy between re-exam proceedings that the office is bringing versus expungement, and that is because we use the re-exam to go after the specimen form cases, which we are going to discuss. But when it comes to whether or not director-initiated proceedings are effective at eliminating deadwood on the register, by and far, our success rate is almost 100% for these. I mean, we are at 99.86%. And we will kind of highlight some of our successes down the road, but by and far, due to the research that we do ahead of time to make sure that we are targeting, the marks that we feel very confident are not in use, that plays into our success rate with our director-initiated proceedings. Just a little information on registrants' domicile countries. For director-initiated, by far, China is our #1 domicile country that we tend to institute against, followed by the United States. But you can see, we're at 91% versus 8% of registrants' domicile for those countries. But it flips. For third-party petitions coming before the office, the majority of them are targeted against registrants that have a domicile within the United States. However, China is also another big player for these petitions as well. Okay, so that's enough for me for the moment. I'm going to turn it over to Christiana, and she's going to talk about how you can establish your case of non-use.
Thank you, Catherine. So in the next few slides, I'll be discussing what's at the heart of these proceedings, which is establishing a prima facie case of non-use. And this will include a discussion of some of the more straightforward non-use cases we've seen and other use in commerce issues petitioners have raised. So what is non-use? Non-use is when a mark was not in use in commerce as defined by the statute. The statute defines use in commerce as the bona fide use of a mark in the ordinary course of trade and not made merely to reserve a right in the mark. And the definition goes on to include the manner in which the mark must be used. So to establish non-use, you can consider whether the use of the mark by the registrant failed to meet any part of this definition. So were the goods actually sold or transported, or is there evidence that the goods never actually made it to market? Were the goods actually sold or transported in commerce, which is further defined as commerce that may be lawfully regulated by Congress, so not purely foreign commerce. Catherine's going to talk a little bit more about how to gather evidence to support a case for non-use, but it's important to understand what we mean by non-use because that will help you find the best and most relevant evidence to support your petition. And it will help you consider whether it's worth pursuing a petition in the first place, depending on what your investigation shows. Now, one thing I want to mention is that for these proceedings, and Catherine kind of mentioned this in the beginning, there is a particular time period that we're looking at, and that time period is important. So you're not looking at non-use generally, you have to show non-use for the relevant time period. For example, for expungement, you have to show that the mark was never used in commerce. So if you find evidence that yes, at the time of registration and shortly thereafter, the registrant was making use in commerce that meets this definition, but the problem is that they're no longer using it, that's not going to cut it for an expungement petition. You can maybe show abandonment, but that's, what Catherine has said, that's something that you would bring in a cancellation proceeding before the board and not an argument that would support a case for non-use. So as we talk about non-use and use in commerce, just remember that it has to be shown for the relevant time period. So let's start with a more straightforward case we see in petitions, and that's one where the petitioner asserts that they can find no use at all of the mark in connection with the goods or services, either now or in the past. So this might present itself where the registration covers a list of goods, but a reasonable investigation shows that the mark was ever only used in connection with some of the goods in that list. And that's sort of like the software with the sunglasses example that Catherine had mentioned. Or the petitioner might show that the specimen itself was a mock-up and that at the time of filing their 1A-based application, they had not yet sold or transported those goods or any of the other goods in the ID. And so assuming that you're within that 5-year period, the petitioner could file a reexamination petition challenging all the goods in the registration. So these are more the classic cases of non-use. I looked, you weren't even using the mark, or you weren't using the mark on all the goods and services in your registration. A second and related type of non-use case is one where the mark does show use in connection with certain goods or services, but the case is based on the mark not being used on the goods or services as specifically identified in the registration. So to illustrate this type of non-use case and how it differs from the one we had just talked about, I'm going to talk about one of our proceedings that was subject to an appeal before the board. So in re locus link involved two expungement proceedings that were filed against registrations for the marks smart lock and standard characters and smart lock and design. In this case, there was no dispute that the registrant was using the smart lock mark on the goods, and you can kind of see it here. They were using it on some type of fitting or connector, and you can see that what the ID was in the registration. But the question was whether it was used on the goods as specifically identified in the registration. In other words, do we read this ID as saying it's components for evaporative air coolers, which could encompass these goods, or should this ID be read as components being evaporative air coolers, which registrant had admitted it did not provide evaporative air coolers? So ultimately, the board found that the identification referred to evaporative air coolers being components. And so because registrant had not shown any use of the mark with the evaporative air coolers, the board affirmed the decision to cancel the two registrations. So this goes to show how important it is on the trademark prosecution side to accurately identify your client's goods or services when filing an application, and how on the petitioner side, you can challenge a registration based on the use not being encompassed by whatever is in the ID. This is just a non-exhaustive list of other use in commerce issues petitioners have raised. With the intrastate only, that was actually one of our earlier petitions that we instituted on. And in that case, the petitioner was basically arguing that it was not use in commerce because they had only ever sold their goods locally in Virginia. We've also had petitions that allege that the services were only provided in a foreign country and were never provided in the US, or that the sale of the goods were unlawful and so it was not lawful use in commerce. And we also had some petitions based on arguments that weren't sufficient. So as we mentioned before, we're looking at whether there is use as of the relevant date for reexamination or whether it was never used for expungement. And sometimes we've had petitions only present evidence of current non-use only. So like I looked at their website today, I did a Google search for today and I didn't find anything. Okay, well that alone does not establish a prima facie case. So because, as Catherine will later talk about, we want to see evidence of past and current non-use over that whole time period or whatever the relevant, around the relevant date. And finally, another type of use in commerce issue is token or de minimis use. And basically that's when the use was not in the ordinary course of trade. To discuss that topic, I'll talk about another case. It's not an expungement or a reexamination proceeding, but it's instructive on like the types of things that we're looking at when we're talking about use in the ordinary course of trade. So this case was an inter partes cancellation proceeding. Adamson had alleged that PV had abandoned its registered CS mark for amplifiers. And in attempting to show use of the mark, PV was able to only present evidence showing only 3 domestic sales over a 6-year period. And in a few of those years, there were no domestic sales at all. The board found that these de minimis domestic sales were insufficient to constitute bona fide use of the mark in the ordinary course of trade. So although this was an abandonment claim, the board noted that the statutory definition of abandonment reiterates the standard of use in commerce. So their interpretation of what constitutes use in the ordinary course of trade in this case is instructive. And here the board acknowledged that use in the ordinary course of trade can vary over time as markets and businesses change, but found that sporadic, casual, and nominal use does not meet that standard. And this is kind of a reminder too that even though these proceedings are relatively new, use in commerce and case law relating to use in commerce is not new. So many of these cases can be very helpful when you're evaluating whether to file a petition. So now that I've talked about how use in commerce is defined and different ways you can establish non-use, I'm going to turn it over to Catherine to discuss different ways you can gather evidence.
Great, thank you. Okay, so let's jump in and discuss the evidence requirements here. Okay, so in order to show your reasonable investigation of non-use, spoiler alert, you need evidence. And not only do you need evidence, but you need documentary evidence. So what do we mean by that? We've been talking a lot about that. The TMA requires documentary evidence. What we mean by that, that would be number 2 on this slide. Essentially, not only do we need a narrative, which is number 3, which I'll get to for the petitioner explaining what it is you've done to investigate non-use, but you need to submit your actual copies of what the evidence of the items that you've looked at. Essentially, you need to back up some testimonial evidence with documentary evidence, and that is required under this rule. So like everything before the PTO these days, if you are submitting screenshots, you do need to include the URL and access date of those screenshots. One of the biggest issues that we face with petitioners is that they do not submit an index of their evidence. An index is absolutely required. So you can include your URL access date, an access date on the index if you wish. You can have, whatever you're using to screenshot your evidence, just automatically capture that information for you, and we'll find it on that page. But if we do not have the URL and of that website that you've reviewed and the access date of when you reviewed it, somewhere within the body of the petition, we will have to issue a 30-day letter to obtain that information. Or if you don't include an index of the evidence that you're submitting, it does not have to be formal. It can be very simple, just bullets, or numbered list of the evidence. But that is the quickest way that you can avoid getting a 30-day letter from us, which of course delays the process of us potentially instituting here. So what am I talking about when I talk about the evidence? We're going to show you specific examples in the upcoming pages, but evidence could consist of the websites that you go to, the registrant's own website. If you're searching state and federal trademark websites, give us copies of those. Google searches. We love Google searches, and I'm not singling out Google. You can use any third-party search engine, but please, that should be the first step. And a lot of people get confused because if they're not finding the mark, or if they're not finding a lot of information, they think that they shouldn't submit the evidence or copies of it. But as we note here, a single internet search is not sufficient. We want to see copies of, I don't want to say everything because I don't want to jinx ourselves and have, thousands of pages submitted. But if you're doing an on-point search for the registered mark and, niche goods and nothing is coming up in Google, submit those searches. That's what we call negative evidence. And that's what we love to see, because if somebody is using their mark in commerce, especially, if it's goods and they're foreign based, they should have some sort of U.S. internet presence, you would imagine. How else would U.S. consumers be buying their goods? So just submit those screenshots. That's the biggest takeaway. Submit, submit, submit. But in addition, we also want to know your story. We want to know your narrative. Explain to us what information you relied upon, how you obtained it. If you emailed the registrant to ask them specific questions, hello, registrant, have you been selling T-shirts in the United States? And they respond and they say, no, we've never sold a T-shirt, and we don't do business in the United States. Describe that process to us in the narrative of your petition, and then include a copy of that email. So essentially, help paint the picture for us. We want to hear about the search that you've done, about the investigation that you've done. It could be as simple as you saying that you hired an investigative firm like Marksman, but then include a copy of that investigation. Include screenshots of the search results that the investigator included within that report. We will get into that in a little bit later, but that is required. If you are using a investigation report, we do want to see the actual copies of websites or search results that were discussed within the report. So that basically gives an overview of the type of evidence that we are looking for to create that prima facie case of non-use. But this pyramid here basically shows us that we do like a variety of evidence. So again, past non-use is key. I mean, that is ultimately what we are looking for. But something like past non-use in combination with perhaps current non-use, a bad specimen, or if there's evidence of fraud, highlight all of these issues. These are all things that you should bring to our attention. They're going to raise an eyebrow. A bad specimen by itself may not be sufficient to establish non-use on its own. Our specimen rules before the office require an applicant to only submit one specimen. So, the registrant could very well have other legit specimens in their toolbox that perhaps they just, for whatever reason, didn't submit the first time around. So if we instituted, the registrant may be able to show us, a better specimen. But if there is a bad specimen, in combination with no current use, in combination with maybe a bad actor, we have several bad actor filings before the office. So if you see that perhaps a suspended party is associated with the registration, or if you suspect fraudulent filing, highlight that for us. That is absolutely something that we would want to know about, and it helps to paint that overall picture of non-use for us. I talked about this a little bit, but I refer to bad specimens, but what exactly is a bad specimen? That could be a fake or doctored image, or perhaps the specimen, shows something like only intrastate commerce, use within a state. The application could discuss, it could show potential areas of fraud, like if perhaps a specimen has atypical features that we don't normally see on an e-commerce website. We're going to get into that when we discuss our specimen farm filings. Perhaps you see that there's a wide variety of goods, or you notice that the registration is, listed on an auction website. So maybe as soon as the registrant received their registration number, they went ahead and listed it on an auction website for sale. That certainly raises our suspicion. But going back to the past non-use, the Wayback Machine. If you're not familiar with it, you don't have to use it, of course, but the Wayback Machine is extremely invaluable. If the registrant has a website, plug it into the Wayback Machine and see what comes up. Now, not everything is going to be captured on the Wayback Machine. It doesn't capture everything. But if it does capture the website and you don't see the mark on it, or if they have their product listing and the mark isn't on there as of a period of time, highlight that for us. And we do have an example in the upcoming slides of what I'm talking about for Wayback Machine captures. You can also do targeted searches in Google. You can limit the date range in Google and other third-party search engines. So essentially, you can search for the term and limit the search results to, let's say, 2023, to see what comes up. But all types of searches like that are extremely effective for helping to prove that a mark was potentially not in use as of the relevant date. And then real quickly regarding current non-use, current non-use in and of itself, as Christiana touched on, does not make your case for non-use, especially before a relevant date, but it does raise our eyebrows. It is suspicious. If somebody hasn't involuntarily, filed their cancellation or Section 7 rather to cancel their mark, they're claiming that they're still using it, but we can't find evidence of current use, especially if it's a foreign registration, a foreignly owned register, and there's no, it doesn't seem like U.S. consumers would have a way to reach out and utilize their services or order their goods, highlight that for us. Find those search results for us. That would definitely help to make that prima facie case. Okay, so here are some real life examples from evidence that we have seen. This slide demonstrates a screenshot from the Wayback Machine for this website. The purple arrow at the top highlights the date that they were searching. I believe this was November 18th of 2020. So that clearly shows us that this person was searching before the relevant date. At the left, the other arrow at the left shows that there was one capture, and it also shows that date again. So we have a clear picture here of a search that was completed before the relevant date of this proceeding. This would be helpful because although the Wayback Machine did capture the website, it looks to us like perhaps the website really wasn't up and running. It almost looks like a beta website. It says join our journey soon. You have to put in your email address. This looks like, maybe there was supposed to be a picture that loaded and perhaps it didn't. So this to us sort of looks like this website was not forward facing. It wasn't being offered to consumers. This in and of itself, of course, doesn't prove that a registrant wasn't providing goods. Maybe they just didn't have their website up and running. Maybe they were selling it at local stores. But this would certainly be an effective tool to help paint a picture of non-use. Likewise, these are screenshots from Yelp. The petitioner did, in the original petition, also include the relevant date captures on these as well. So we were able to see, when the report was made that these locations had been closed. But essentially, the petitioner found that this registration was for restaurant services, was permanently closed before the effective date, before the relevant date of the proceeding. So finding information like this that says, a restaurant is closed, certainly, would raise our eyebrow and certainly seems to show that the registrant was not providing services. If there's a digitally altered specimen in the record, highlight that for us. It could be perhaps the registrant just stuck their mark on a stock image, like from Getty Images, or a similar, stockpile of images like that. If they're just going out and finding, images of other products on the web and, putting their own mark on that, that pretty much, signifies to us that they are most likely not using their mark on their own products in turn, and they're certainly not providing them to customers. So this is a way that you could highlight perhaps a digitally altered specimen in the record for us. As Christiana mentioned, sometimes we do have the question presented to us. They're saying that perhaps a registration was only used overseas. Perhaps it's a foreignly owned registration, and perhaps they weren't actually providing their goods or services in the United States. Or within, the definition of use in commerce, commerce that the United States Congress can regulate. This was a screenshot that was presented to us. This was a foreign-based company. They were providing all kinds of aquariums and fish-related products, so actual goods. And in their website, they had a drop-down menu that basically showed all of the countries that they, either work in, provide their aquarium-related services, or that they ship their goods to. The petitioner highlighted this for us. They showed that the United States was not listed as one of the countries. And then they also followed it up with an email to the company, basically saying, hi, I'm in the United States. I'm interested in your products. Do you ship to the United States? And they included a copy of that. Now, do keep in mind, if you have a relevant date, if you're doing re-exam or even with expungement, make sure that, perhaps at one time they were not shipping to the United States and that they just stopped. For example, this was a very interesting piece of evidence. This is from a UK-based company. And on their website, it said, we are not shipping to the United States at the moment. Well, what does that mean? Does that mean, yesterday you were and now you're not? Are you just not shipping because of potential, things going on, let's say tariffs or new sorts of regulations? But if you had a re-exam proceeding and your relevant date was, let's say, in 2023, I would want to know if they were previously shipping to the United States. So while this is certainly an excellent piece of evidence to raise our eyebrows about whether or not you're currently using the mark or providing your goods to the United States, we would want some more information about, was this just a recent decision? Also with this, it goes on to further say that you can still shop essentially their third-party partners in the United States. And if you clicked on that box, it just sent you to retailers within the United States that offered these goods. So this piece of evidence ultimately in the end was more so in favor of the registrant, showing that they actually, were legit, still providing goods to the United States and that they had provided their goods before the relevant date, even if they had temporarily stopped. But again, still very good to explain, very good to highlight if you think it's relevant for your case. Evidence from a registrant's social media pages can be extremely helpful in making your prima facie case of non-use. It's amazing what evidence you can get from social media pages. For example, the box on the left, this was from a clothing company. The petitioner was petitioning against footwear. Essentially, they were saying that the registrant had never provided footwear. They provided a copy of their Facebook page, of the registrant's Facebook page, that is. And on the left, it says footwear coming soon. And they also included screenshots of the registrant's website that also said footwear coming soon. And they did way back captures as well, showing that footwear was coming soon, a few years ago. And currently it's still coming soon. So they, basically utilized all of that evidence to make the case that this that this registrant most likely was not providing footwear, that they previously were not providing footwear, and that they still currently are not providing footwear. On the right, this is a cosmetic company. This was a re-exam proceeding that had a relevant date of before September 18th of 2019. That's circled at the bottom. And this petitioner found on their social media page that this company was saying, introducing our first line, stop by this Friday to get yours. Online ordering is available soon. So it paints the picture that perhaps this registrant wasn't providing these goods before that relevant date. If the registered mark in question consists of a design element or perhaps wording and a design element, please do not forget to search that design element. A lot of times, especially if it's a combination of wording and design, we will get petitioners that just search the wording element, but we also need to see that you've searched the design element. You can do a reverse image search in Google or other search party engines, or you can use companies like TinEye. This is a free search. You just take a picture or screenshot of the image and then you upload it, and it will search the internet for that or similar images. So please make sure that if you have a design mark in question, that you show us that there are no results, or no relevant results. Perhaps you find use of the mark, but it's not the registrant's mark, or you do find use of the registrant's mark, but it's let's say not in connection with footwear. Highlight that for us. This is an example of what I was talking about earlier of a registrant using their image on a third-party good. If anybody has kids, they've probably recognized this product. This is a very popular Fisher-Price kids table. We had a registrant that was just throwing their mark on these goods. These goods are extremely easy to find all over the internet. They're sold on tons of third-party websites, Walmart, Target, Amazon, as well as directly on the Fisher-Price website. So this petitioner was able to, show us that not only can they not find this mark used in connection on this good on the actual registrant's website, but that the registrant appears to have doctored their specimen when they submitted it before the USPTO in their initial application. Another thing we look for is industry-specific evidence. So if you have a mark that is a niche product or a specific industry, and let's say that industry requires certain licensing or regulation, or should be, registered or obtain a certificate from a company or a government agency, highlight that for us. If you're targeting a pharmaceutical company, show us whether or not they're registered with the FDA. If it's a finance-related company, check the SEC or the FDIC, and explain to us, provide a brief narrative saying that, for example, this registrant is providing dietary supplements, and companies like NSF and USP are third parties that certify dietary supplements. I did a search and I don't see them listed. They should be listed if they're offering legit certified products. And then talking again about the negative evidence, this is an example of the National Futures Association. Apparently, they regulate commodities trading. If you type in the mark and nothing is coming up, it's very hard to see on this slide, but we did have the mark and it says no search results for the mark. This would be an excellent piece of what we call negative evidence. You could tell us, very briefly that this registrant, is providing these services and they should be regulated or, registered with this company. I did a search and they're not. For all we know, perhaps maybe the registrant falls under some exception, maybe they're not required to, but the registrant could explain that later on down the road when they respond to the institution. But when you make your prima facie case up front, providing this information is extremely helpful. Just another example, if you're targeting a drug-based registration, we all know that FDA, regulates drugs and medicines and like goods, but they also go so far as to provide authorization for the specific form that the drug is offered, perhaps in capsule, oral, liquid form. So we had a petitioner that showed us that the registrant, not only wasn't regulated by the FDA, but that they had previously received approval for a capsule form, whereas the specific registration, I believe it was in tablet form or something like that. So, the petitioner was able to show us that the registrant never went through with actually obtaining FDA approval for that specific form that the drug was listed in that registration. So those are just some high-level examples that we've taken from real-life petitions, but that just gives you a sense of the type of evidence that we are looking for in these petitions. So I will turn it over now to Christiana so she can give you the real tips that you've been waiting for, basically how to avoid pitfalls with these.
Thank you, Catherine. So I'll be talking about some of the procedural mistakes petitioners often make and how to avoid them, as well as best practices when filing a petition. So if I could get control of the slides. And some of this is kind of a recap of what we've kind of highlighted before, but hopefully this next format will give you a nice summary that you can keep of the things that you should do and should not do when you're trying to file a petition. So first, do provide an index of evidence, even if you only have a few exhibits. Provide the name, domicile, address, and email address, do this housekeeping stuff. As I think Catherine had mentioned before, sometimes we can fix this with a 30-day letter, but that really delays the process. So to the extent you can just make sure that you're hitting these kind of more procedural admin type requirements, that would be great. When you're supporting your case with evidence, do provide more than just an assertion that the specimen is fake. Again, as we said, we want to layer the evidence. You want to supplement with different types of evidence to kind of make that story and get those inferences of non-use. So that way it kind of creates this compelling narrative that there was no use in commerce. Another suggestion is to check out our sanctions page to see if the attorney record has been sanctioned. Sometimes the sanctions order has great language of some of their behavior when they were dealing with specimens, so that might further support an inference of non-use. When providing search evidence, do provide that industry-specific search evidence that Catherine was talking about. You can provide the Google search results as well, which will help supplement your case, but don't only provide hit lists of Google. We sometimes see evidence where folks are just doing like a quick Google search and just kind of focusing more on the narrative, but not actually providing that documentary evidence. So make sure you're providing that hit list or more than just a hit list, and actually providing screenshots of other industry-specific searches, and also providing the websites themselves when it matters. And for websites, we want to see a screenshot of the actual website and also the complete URL and date accessed. So a couple of things to avoid. One, don't try to use this proceeding to attempt to narrow the registrant's ID. So if the registration covers nutritional supplements, don't provide us with evidence that the registrant only sells magnesium supplements, and then request that the ID be limited to only magnesium supplements. This is not the proceeding to make that kind of argument. If they made proper use in commerce of the mark with magnesium supplements, that supports the broad nutritional supplements in the ID. Next, reiterating again that we want the documentary evidence, and it's very important, and it's required by our rules. So for investigators' reports in particular, it's not enough to just submit the report where the investigator says, I searched social media websites, I searched the registrant's website, here are the links. We need that documentary evidence to support it. So when your investigator's report says, I visited the websites, I didn't find use of the mark, make sure you're also including the underlying screenshots. And sometimes we'll see the screenshots included in the report itself, which is fine, but just make sure that it also includes the URL and access date, because oftentimes we'll just have that screenshot and then we are like, when did you access this? Where is this from? So just make sure you're kind of meeting those minimum requirements. For this hooded sweatshirts example, make sure that you're including all of the relevant goods you want to challenge in your petition. One mistake we see petitioners make is that the registration they want to challenge is cited against their pending application, so they narrowly pick out the goods they want to challenge to avoid that 2D issue. But when they do that, they inadvertently leave off other IDs that essentially cover the same items. So if we institute based on the petition, it's limited to the goods or services you identify. So make sure you're identifying all the goods and services you want to challenge. Next, make sure you're using the correct relevant date. Catherine touched on this before, and another mistake we sometimes see is that for a reexamination proceeding where the application was based on 1B and later amended to 1A, the petitioner uses the statement of use date as the relevant date. That is not the correct date to use. The relevant date is the expiration of the deadline to file the statement of use. So that could be months later, depending on how early the registrant had filed the statement of use. So if the petitioner targets all their evidence towards supporting that there's no use before January 1st, 2022, that wouldn't support a prima facie case of non-use where the actual relevant date was like March or May or something. Because now we'd have months where you haven't provided any evidence that there was non-use. Another point is that you need to support a case for non-use for all of the goods and services subject to the petition. So this is not a type of proceeding where you can say, oh, they didn't ever use it as to one of the goods, and so now the whole registration is canceled. Non-use must be established for every good and service that you're petitioning to challenge. And finally, like Catherine had mentioned, do provide that negative evidence. It's basically evidence that you searched for the mark and didn't find anything. That is great evidence to include that helps us to see that you kind of hit all your bases. Because if you're only focused on like what the registrant says or things like that, it makes it hard for us to say like, well, okay, maybe they maybe said that on their Facebook page, but like, what is this, like, are they selling it in stores? Like, did they end up posting it somewhere else? So just make sure you're kind of hitting all your bases. So these are some of the things to avoid in petition, and also some tips on what you can do to increase the likelihood that we'll institute a proceeding. So I highly recommend, print this out, just like to make sure you're kind of hitting like, what are the do this? And then also making sure that you're double checking the stuff on the not that portion. So next, I'm going to talk a little bit about our director-initiated proceedings, and that includes the interplay with petitions-based proceedings, and also some of our successes with using these proceedings to challenge what we call specimen farm websites. So as Catherine mentioned before, director-initiated proceedings are proceedings that are not based solely on a petition, but we're making our own case on our own initiative. So it's the same standard as the petition-based proceeding, and we're doing the same investigation, including very similar evidence to what you'd submit in a petition. And these proceedings have been a very effective tool for removing unused registered marks. As we mentioned before, a petition-based proceeding can only be instituted as to the goods or services identified in the petition. So sometimes we'll use these director-initiated proceedings to supplement a petition-based proceeding. So for example, we might review it and say, wow, this is great evidence, but they only challenged like 2 of the goods in this list. But really, because they've shown that this mark has just never been used anywhere with any goods or services, that could, support a case for the entire registration. So in that case, we could bring a director initiated and kind of capture the rest of those goods. Or sometimes the petition, sometimes we'll supplement where the petition might be defective for some reason, but there's such strong evidence of non-use out there that we might end up instituting, and we might say, like, here's your notice of non-institution. We couldn't institute based on your petition, but then later on we do a director initiated. So that's just supposed to say that if you get a notice of non-institution, so if you file a petition, you get this letter saying that we're not instituting, and you want to file another petition, just make sure to check the record before you file another one to see if maybe we did end up taking action and instituted our own proceeding. But our biggest use of the director-initiated proceedings so far is our ability to go after what we call specimen farms. So I'll talk a little more about what they are. But together with cancellations resulting from petition-based proceedings and all our director-initiated proceedings, we hit a major milestone of over 50,000 goods and services canceled since the introduction of these proceedings. So this shows our growth and increased efficiency as we continue working on these proceedings. And while many of these goods and services were canceled due to petition-based proceedings, a majority of these cancellations were from director-initiated proceedings relating to specimen farm websites. So what are specimen farm websites? So in the past 5 years or so, we've had a huge surge in trademark applications for various reasons. And what we realized was that there were certain bad actors out there who had created websites for the sole purpose of submitting a specimen to support lots of different trademark applications. So they'd prop up some website, usually a Shopify or other e-commerce website, and create hundreds of listings with various marks. Now, when a trademark examining attorney is reviewing the specimen looks like it's a real online product listing because it's kind of just like they're just submitting that one page for the website. And it's only if you dig further and look at all filings using this website and you look at the website itself that you realize it's not an actual functioning e-commerce website, but it's basically a mock-up used to support registration. So oftentimes the marks in these registrations, Catherine kind of mentioned this before, they're sometimes showing up in trademark auctions, sites for sale. So in many of these cases, it seemed like they were just getting these trademark registrations fast so they could quickly sell them to other people who wanted a registered mark. So that way they can get on the Amazon brand registry or just be able to have all the benefits of a registered mark. So I'm going to show you a couple of examples of what these websites look like to help you identify a specimen farm. So here the website was a storefront on wish.com, which is an online marketplace type site, kind of similar to Amazon. This particular seller had listed a wide variety of products, as you can see here, from keyboards to clothing to mouth guards. The website even offered a bus for sale that you could buy for only like $15,000 with the low shipping price of only $12, even though it's coming from China. That's a great deal, suggesting that there was no intention of actually selling or shipping this item. Some of the listings included the identical product image, but a different mark, showing that they were creating these websites not to sell actual goods, but just to make it look like they were selling these goods so they could submit it as a specimen. Here's another example. As you can see here, the main page contains only placeholder language, and the catalog page just has this wide array of goods with no categorization. And just to note, this is often not what, like I said before, this is not what the actual specimen shows. A lot of times the examining attorney is seeing like the underlying product listing page, so it's not evident to them that, that the main page has like no text on it or that these products are sorted like this. You can also see here too that a lot of these are like have very odd backgrounds. It's like the white background. One of the, I don't know if you'd want to buy a kitchen knife that's on like the floor like that, but there are a lot of oddities when we're starting to look at these specimens. this just talks about kind of the evidence that we're looking for. This is the type of evidence we use to support our cases, but it also could be used to support a petition. In fact, we discovered some of the specimen farms we took action on based on really well-supported petitions. So we appreciate folks who have taken the time to alert us to these specimen farms and essentially provide us with like the base of evidence. That way we could pursue multiple registrations relating to the same website. So one type of evidence is kind of hitting on those atypical features. So that's sort of like the lack of categorization, the placeholder language. Look at whether the product listings are copied. Sometimes because they're just kind of creating these mock-ups, they're just copying and pasting product listings from like Amazon, or they might even copy reviews. Like we found some pages where the reviews even continue to list the third-party product that's for. So that's been really helpful in terms of being able to supplement our cases. And the biggest hallmark of a specimen farm website is that it's submitted in specimens in multiple trademark applications. So do include examples of other registrations or applications where it was used as a specimen. This is an example of the first specimen farm case we did and the index of evidence. And this is just to illustrate that when we're doing a director-initiated proceeding, we're doing the same thing that you would do in a petition. We provide exhibits, index of evidence, that whole narrative statement. It also shows how far we've progressed in terms of identifying specimen farms and taking action against them. Because here, the set of cases only involved less than 20 registrations, but since then, we've issued proceedings against hundreds and sometimes over 1,000 registrations for a particular specimen farm. Many of which were listed on one of these auction sites. This is an example of a fabricated invoice we used as evidence in one of our proceedings. In this particular case, we realized that in at least over 50 files for completely different marks owned by completely different owners, they were recycling the identical tracking number. For other invoices where they don't redact the customer address, we kind of include evidence showing that a lot of these customer addresses are fake. Evidence of fabricated invoices are a type of evidence that can also be used to support a non-use case. And finally, this is an example of an auction website. So for this particular screenshot, you can see that they say registered unused, which we use as evidence in our cases. Presumably, unused trademark sounds more like brand new and enticing to buy than one that's used. After we started sending the actions, they immediately deleted unused from their website. And since we've instituted these proceedings, this particular site has gone from having thousands of US registrations to only listing like a couple of hundred. So we're hoping that by continuing to do these proceedings, we can, in addition to cleaning up the register, change behavior among these filers. So this slide includes some helpful links and resources you can use as you're drafting your petitions. We have our TMA page, a link to the final rule. And if you want to review previous decisions or look at other proceedings, you can find them on our decisions proceedings page. It's a great resource to kind of see like, what are we instituting on? You can narrow it down by like where there's notices of termination, by type of action. So it's a great resource for that. So that concludes our presentation portion of the session. We'll now proceed to the question and answer portion.
Okay, well, thank you very much, Christiana, and thank you, Catherine, as well. We are going to jump into some questions. Let's see, Chris, if you could post a link to the TMA proceedings page, maybe there in the chat for the folks, so they can have a quick and easy way to check out some of those decisions that were being talked about. I did see a question there about, what are some good examples of good evidence, and folks might be able to kind of go through some of the proceedings there and see the ones that were working. Okay, so before we get into questions, I did have one here that I wanted to make sure I addressed off the top. I should have said this in the opening, but Leonid had asked whether CLE credit is available for this, and the answer is yes. We've applied for and received CLE credit from Virginia, the Virginia Bar. And so what will happen is after the presentation, it'll probably be later on this week, I wish it was right away. Unfortunately, it can't be, but it will be as soon as possible. We're going to send an email to all attendees, and with that will be a form that is a certification of attendance, and then you can use that to apply for credit in your home state or Commonwealth if you don't happen to be a member of the Virginia Bar. So that's how we do that, and I think it should be for 90 minutes. So you should get a free 90 minutes. And also, by the way, that's a nice thing of the Experienced Practitioner webinar program. That gets you about 6 hours of free CLE credit every year. So hey, there you go. Okay, so let's jump into some actual questions. So some of these that we're going to hit first here were ones that people had asked in advance. Catherine, let me hit you with this one. So kind of a biggie, but why would a person file an expungement or re-exam proceeding versus a cancellation proceeding with the board? As people are trying to figure out which is the better way to go. Any thoughts? And again, there's no necessarily right answer, but what are your thoughts on that?
Sure. Well, first, it's cheaper. So we're all concerned about costs these days, and filing one of these petitions is cheaper. It's cheaper not only with the filing fee that the office charges, but it could be cheaper in the long run for your client because once you although you have to do the work up front of, establishing your prima facie case of non-use, once you submit the petition to the office, you're pretty much done with the proceeding. We may send you a 30-day letter if there's something, correctable in the petition that we need, like the index or the petitioner's domicile information or something like that. But overall, once you file the petition, it's then up to us in the office to review it. And if we decide that you have met your prima facie case, we go ahead and we step into your shoes, and the proceeding is now between the office and the registrant. So in the long run, there's less for attorneys to do on behalf of their clients, or if you're filing pro se without an attorney, that's totally fine as well. But in the long run, it could be, cost effective that way. In addition, they are more efficient, we believe. We tend to work on these pretty quickly, so they could be, resolved quicker than at the board. The one thing I will say, though, is that if you are hoping to receive a default judgment, if you think that the registrant is simply not going to respond, maybe there's been other proceedings filed against the same registrant on the board and, they've all resulted in default judgment, perhaps that might be a better avenue for you to explore if you think that the registrant won't, respond and you think you can get a quicker outcome that way. Of course, explore that.
Okay, great. Good. Yeah, as always, it's going to be kind of fact dependent, right? Sort of like what you have, what you're going for, and how soon you need it done, and whether money is an object. Okay. All right, cool. Great. Thank you for that. So I'm going to table tennis it over to you here, Christiana. So do I need to provide evidence for every single good or service that I wish to provide non-use for if I'm using one of these proceedings? I know you talked about this already during the presentation, but I think it's a good thing to highlight for the folks. So is it for every single good or service that you're going against? That's what folks need evidence for?
Yes, so that is correct. That's a great question too. It's just that you want to make sure that you're providing evidence, that your evidence establishes a prima facie case of non-use for every single good or services that you're challenging. But I do want to clarify too that it's not that, kind of going back to creating that narrative or story, it's not that you're going to do a one-to-one where you're like, okay, for this good, these 4 pieces of evidence support non-use for that. A lot of times you're creating this narrative or story that hey, this registrant is only doing swimwear. They have, I searched and I don't see them providing anything else. And even on their website, they say we're a swimsuit company. So that's not supporting the wedding dresses in there or the random shoes or ski boots or that's in their long ID. So just kind of clarifying that you do have to present the totality of evidence has to support that every good that you're challenging or every service you're challenging is not in use, but you don't have to do that kind of that one-to-one. It's not some impossible standard of I need to have 5 pieces of evidence for each thing. It's basically you need to tell us and support this narrative of why there's non-use as to all of these goods that you're identifying.
Gotcha. Great. Yeah, and I can see how that would be extremely burdensome, not just for the people reviewing the petitions, but for the actual petitioners. If you had to do, here's 10 pieces of evidence for every single thing. So,
Yeah.
and there'd be a lot of repeated evidence in there as well, which
Right.
would not be great. Okay, cool. Great. Thank you very much. All right, Catherine, let's jump back to you. Let's see. Let me hit you with
Actually,
this one.
Jason,
Yeah.
just to tag on to what Christiana said here,
Mhm.
going back to the example that she used of if the registrant says, "Hey, we are a swimwear company, and we only provide women's swimwear. We're the number one women's swimwear provider in the United States since 1984." That, like we had shown you the examples of using the registrant's own statements. If they have, men's swimwear in the ID and that's what you're targeting, that's an excellent piece of evidence to submit. It's essentially using their own words. I don't want to sound mean, but against them,
Sure.
and then you perhaps just include a Google search of that mark in men's swimwear and show that nothing comes up. But that would be a huge piece of evidence to include.
Great. Good. Thank you for that. Good to know. All right, I'm going to stay with you. Okay. So,
Okay.
a question here. So, here's a situation where somebody doesn't have a huge, overwhelming amount of evidence that they're including. It's just a few pieces of evidence that they're including with their petition. Does this person still need to include an index?
Yes, absolutely. Yes,
Okay.
yes, yes. An index is required per the rule. We are required to have a complete petition before we can institute. So if your petition is not complete because you don't have that index, we will have to send you, the petitioner, a 30-day letter, which then, as we've discussed, can delay the process of, by the time you respond, by the time we review it, and get that notice of institution out, it could, unnecessarily delay things. So even if you are just submitting one piece of evidence, which we definitely do not recommend. Again, remember, think about making that prima facie case. But even if, you have some slam dunk pieces of evidence and it's just a handful of pieces, a simple index, basically we need to be able to have a clear listing of what it is you're including. We can't dig through the petition to find that evidence. We need it right there in that index before we can move forward.
Gotcha. So in many ways, you're trying to front load that petition. Just get everything that you might need, get it in there, have it all set. All right, in order to help speed it along, especially if speed is one of the benefits of the program. Okay, good, great. All right, Christiana, that means I'm going to come back to you. Let's see, we have a question here from. Okay, so let's say, and I think we talked about this already during the presentation here, but if a registered mark includes both a word element and a design element, all right, so we got that combination of wording and a design. Do I also need to provide evidence of non-use of the design? Okay, so
Yes.
the registered mark has both, but so the question is, do they have to provide evidence of the wording and the design?
Yes, so the petition has to be complete, and so you want to make sure that you're showing that they didn't use the mark as registered in its entirety. So sometimes we have seen this mistake before where they're really focused on the word element, but sometimes like when you're conducting a search, you might not pick up maybe something that's substantially exact that we would allow to establish use of that mark. But maybe it's like not coded that way correctly. So if you're not submitting an image search that shows the design with a particular wording, or if the wording is really stylized, it's not really giving us that complete picture. And if you're just focused on the words, you may not show all the results that might be relevant. Even when you're doing an investigation, like you yourself might realize that like, oh, I'm not seeing anything. And then when we're looking at the petition, it's like there was a dead on, lots of use of this particular mark. It's just a slight variation. And then we wouldn't institute because there wouldn't be that case for non-use because you didn't do that sufficient search and there was actual use. So that kind of also goes to variations on wording. I guess like if you have a mark, especially for marks that have a lot of words or longer, you want to kind of include the variations because you don't want to just have searches that are only searching like components or things like that. And so that might not exactly show all of the search results for the particular mark that we're looking at. So.
Got it. In many ways, it's using those clearance search skills
Yeah.
all over again, just sort of in a
Right.
different capacity, right? Well, it's still doing the same thing. In here, you're still, if you're trying to establish or do a clearance search for your client, you want to clear the area. So it's the same way here. You're clearing, nope, wasn't used. So a lot of the same thought process. Okay. Okay, good. All right. So, Catherine, I'm also taking a look at the time. We have 11 minutes left. I think we're going to be able to get through some of these and also grab a couple questions that folks submitted during the presentation. So, doing good. Okay. So, a question here. Yes, I know this was talked about already, but let's highlight it here. Can I withdraw my petition if I negotiate a settlement agreement with the registrant after I file the petition? So, the person has submitted, and then they go off and talk to the registrant. Can they pull that petition back if they settle?
Well, yes, we did talk about this. The short answer is no, they cannot. But I'm glad that someone asked this question because it does show how relevant this comes up. It's come up quite a bit. And again, because when a petitioner files one of these against a registered mark, that usually starts the conversation between the parties. And sometimes settlements are reached, or sometimes negotiations happen, and then the petitioner wants to back out and withdraw it. But like I said, the language that's actually used in the TMA is that if the prima facie case is met, the office has to or shall institute or must. I'm blanking on the actual language, but it's essentially saying that, we must go ahead and institute. So in that case, we would not allow you to withdraw. If the petition doesn't make its prima facie case, we could perhaps not institute, which is sort of, terminating the proceeding then and there. But it's not the same as allowing a petitioner to withdraw the petition. It still stays in the record, or our decision of not instituting is still in the record, but no decision on use or non-use would be made by the proceeding.
Okay, good. And this probably also again, we don't have a TTAB expert with us here today, and probably a lot of you on the call today might feel like you're TTAB experts, which is awesome. And my thinking is that it's different than the situation that you would have with the TTAB in a cancellation proceeding, where you might be able to institute negotiations, settle, and then pull the whole thing back, right? TTAB often encourages settlement. So if you're a practitioner and you're trying to figure out which proceedings you want to go with, TTAB or one of these TMA proceedings, maybe that plays into it too, as you're making that determination about, like, what do I think is actually going to happen in this case? Right. So another good thing to consider. So cool. Thank you very much, Catherine. All right. So here we go, Christiana. Do I have to show the results of my search when I received 0 hits? Okay, so we got a person here doing a search for the mark and or for the registrant, 0 hits. Do they have to show that negative evidence there?
Yes. So as we mentioned before, like, you need that documentary evidence. So it's not enough for you to just tell us that. And sometimes we'll see this in the narrative and even the investigator's report. They'll say, I looked at XYZ and I saw nothing. And then I looked at, these other places and I saw nothing. And unfortunately, unless you actually provide us with those underlying screenshots with the URL and access date, we can't just rely on that statement. You actually have to provide that documentary evidence to support the statement, which means you're showing us the 0 hits. And so a lot of times, that's it's great evidence to submit, and it's one of those things where you just make sure that, like, for Google in particular, like, include that complete URL somewhere, whether it's on the page or in your document. But it is very compelling for us when we see that you search this unique term and, like, nothing is showing up on the internet or on any other places. So, so definitely don't make the mistake of not including something, and then we're only looking at, like, 2 exhibits, and then it's, we unfortunately can't institute based off of that.
Got it. And so, that's not just going to be things like your Google and Bing and Yahoo's and DuckDuckGo's, right? That's going to be the other places too. I know there were slides there about the FDA, and I'm assuming whatever is the Alcohol and Tobacco Tax and Trade Board, like TTB, like those sorts of things. We get negative evidence in those situations as well.
Yes. Yeah, definitely support it with documentation. Like, if you're going to say something, support it. So can we come up with, like, a catchy slogan for that?
We need a slogan, yes.
say it, document it, put something in there.
Cool. We'll go workshop that. Okay, cool. All right, cool, great. All right, we got about 6 minutes left here, so let's move it along here so we can get to some of these questions. Additional questions here. Catherine, okay, I know this was addressed too, but no problem highlighting it. Why can't we simply provide links to evidence?
I understand the frustration with, with having to make sure your screen capture has the URL, or your date that you accessed it. But this is becoming the USPTO's practice as a whole. Websites are dynamic in nature. They constantly change. They can be taken down in an instant. So if you only provide us with a link, we might not be able to replicate that. We might not be able to copy it and put it into our own search browser. Also, these come through to us as PDFs, so it's really hard for us to copy and paste those links. So we really can't just click on your link. They're not hyperlinked when they come through to the office. So consistent with TTAB practice and the office as a whole, we do require you to actually document and provide the screenshot of those links that you're accessing. I understand the frustration, but we have to do it on our end too. If there's something that we submit in a director-initiated proceeding, or at the board or examining attorneys, they have to do the same thing. So it's equal on both sides.
Okay, good, great. Thank you very much. Christiana, sorry, looking at the clock, 5 minutes. Do we need to attach evidence that is already in the application record?
So no, you don't. If it is already in the application or in the registration record, such as the specimen of use, or if you want to point to like the fabricated invoices, you don't need to resubmit it in the petition as evidence. And in some cases, we would prefer that you don't, because sometimes we'll get like 200 pages, and it turns out that maybe like 50 of those pages is just re-uploading the registration record. So similar to kind of like our other proceedings before the board and everything, if it is in the application record or registration record, that is part of the record for what we're looking at. Now, if you are submitting, for example, for specimen, if you're trying to make a specimen farm case and you want to submit records from third-party registrations, like you want to show that the specimen has been in multiple other registrations, you'll need to support that with evidence. So you'll have to pull those records. You don't have to pull a lot. You can just show that it's registered and then also like a portion of the specimen. But we do want to have that included. So it's really just the records in the one that you're looking at that you don't have to reattach.
Okay, perfect. All right, 3 minutes. All right, Catherine, if a petitioner is submitting an investigative report, do they need to submit as evidence copies of all of the website results identified in the report? I think we talked about this in the program as well. So do they need to submit evidence as evidence copies of all of the results in the report?
Yes. So this is another big miss that we see. There are great investigative companies out there for, we're not endorsing any, but most commonly we see the Marksman report that petitioners will include, and those do an excellent job of providing the narrative of basically explaining what it is that those investigators did. I called the registrant, I searched Google, I blah, 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 blah. But a lot of times they don't then include the screenshots of that Google search or of that, like you said, the alcohol, the regulatory agency for those.
Tax and Trade Board.
I want to say TTAB, but it's not
TTB, I think.
Yeah. So it's great that the investigator did that, but that's testimonial evidence. We need those screenshots. So when you're hiring those third-party companies, be upfront. Let them know that, hey, if you're telling me that you searched the FDA website, I need that screenshot. Go ahead and copy it as you go, because we will issue a 30-day letter asking for that documentation. Documentary evidence is key for these proceedings. We are talking about potentially canceling registrations in whole or part, so we do take it very serious, and we want to make sure the record is complete.
Okay, thank you. We got 2 minutes left here, so Christiana, I'm not trying to rush you, but as quick as you can.
Sure.
So let's say someone is still confused about the type of proceeding to select, reexamination or expungement, filing a petition. Like when you file a petition, is there a preferred filing? Like, should they be using one over the other, or is it fact specific?
Sure. It's totally dependent. Well, first you got to make sure you're eligible. So make sure you're going to see what's the time period. Obviously, if it hasn't been 3 years yet, expungement is not an option for you. So make sure that you're looking to see if you're even eligible. I will say that sometimes we have found that reexamination, if you have the option to do either of them, because it is a smaller time period, so there's pros and cons, but because it's a smaller time period, you're not having to show never been used for like 5 or 6 years. You can kind of focus on the time period. But having said that, it also is a time in the past. And so that can be challenging. But again, I mean, with expungement, you do have to show never been used. So that would include way back in the past as well. So we have found that if you have the option to do both, sometimes reexamination has that smaller window.
Okay. Okay, we are technically at time, but I want to see if I can do this super fast. I'm going to get one question for each of you. Catherine, I'm going to hit you with this one, lightning round. This is from James. What's the timeline between filing a petition for expungement or re-exam and institution versus non-institution?
Yeah, from the date that you file a petition, we aim to examine it within 2 months to 2.5 months. So if you file it today, we would be looking at, August, early September that we would be examining it.
Okay, perfect. And so Christiana, last one for you. If someone, do they need to include a declaration from the Internet Archive to authenticate a web page from the Wayback Machine?
Nope, no authentication required. It's just we consider it like similar to website evidence. You just need the URL, date accessed, and a screenshot from Wayback.
Okay, perfect. All right, well, we are at time. Sorry, folks, we couldn't get to more of the questions. I'm going to take a peek afterwards. We're going to talk to the team, see if there's additional things that we can put out to help answer some of these questions that you might have had. Some of the answers you might find on the TMA Proceedings webpage. Chris, if you don't mind, could you post into the chat the link to the TMA webpage? Folks can use that as a resource. I know there's examples there. There's some best practices and tips and all sorts of things like that. Can really kind of help you break down the differences between expungement and re-examination when it be appropriate. And so also, looks like you already put in the chat. The additional things I was going to ask you to do. Thank you very much, my friend. One of them is about USPTO Hour, which is going to be on Wednesday, June 25th for us here in real time. That's tomorrow at noon. It's going to be about combating trademark fraud and threats. I know that there were some questions that had come in earlier. Hey, could you talk about issues with, applications that have been kind of sitting there for 3 years? What's going on with them? Can we get them cleared out? The Deputy Commissioner for Trademark Examination Policy is going to be on tomorrow. She's going to be talking about that amongst some other things that other experts are going to be discussing. So come on back for that. That's going to be tomorrow. And the other thing too, also wanted to put this out there. By the way, please register for that. As always, totally free. The other thing to put out there is that there is a small window in terms of our hiring right now, and we are hiring folks to become trademark examining attorneys. So if that happens to be you, you're interested in it, there is a link in the chat as well that Chris has posted in there in case you want to have any interest in becoming a trademark examining attorney here at the USPTO. For you patent people out there, you folks with your technical backgrounds and things like that, Patents is also hiring as well. So just want to put that out there. So I think they have a longer open window than we do. I think ours is into early July, but Patents, I think, goes a little bit longer until they get as many people as they need. So if you're interested in coming to work for the USPTO, just wanted to put that into your ear. All right. Well, thank you very much, folks, for being with us today. A huge thank you to our experts, to both Christiana and to Catherine. Wonderful job. Thanks for all the information. And thanks to you, Chris, as well for hosting us today. And really look forward to seeing you guys at one of our next events. Hopefully, that's going to be at one of the USPTO hours that is coming up, or one of our other experienced practitioner webinars, or any of the other events that we do. So thank you very much again for being here. Hope you have a great week and take care.